Welcome back to the Stavrock Murders. I'm your host, Andy Hale. I've got a special guest today, Sally Cohen, who is an attorney that works with me, has been an invaluable part of the Chester Weger team, kind of my legal eagle, my legal guru on the law. And just a little bit of background before we jump into it. Sally went to college at Washington University in St. Louis, attended law school at Harvard, and then worked at a big firm in Chicago in their litigation department. Was a law clerk for the first appellate district court, and then worked for the office of the appellate defender's office, and just joined Hale Monaco in January of this year. And I immediately put her on the Chester Weger team. So Sally was there with Celeste Stack and I this whole year in our journey, the evidentiary hearing, the post-hearing legal brief that Sally drafted. She's really been, kind of the brains behind the legal part of the case, her and Celeste. Sally Cohen, welcome to the podcast.
Thank you for having me. I'm an avid listener. I'm great to be on.
Yeah, there's so much to talk about. This is going to be part like a postmortem, a funeral. I think it's going to be frustrating at times. But what I want to get across to listeners, all people really know is that we lost. The judge ruled against us. People don't really, and they don't. I want them to learn a little more of what the legal standards were, and how, in our opinion, you and me, the judge got it so wrong. And I want to talk about that. And just to set the table for listeners, so we had a 3-day evidentiary hearing, May 12th, 13th, and 14th. We put on our new evidence, was primarily our DNA result and our genetic genealogy result from that hair found on Francis Murphy. It was not Chester Weger. Came back to one of the 3 Bray brothers, probably Edward Bray. And then we had several witnesses who had various stories about Chicago Mafia and things. Roy Tyson, Melissa Smith. We had James Woods. We had Randy Reynolds talking about Bill Dummett's admission. We had forensic pathologist David Fowler. We're going to go through some of that. But let's start here. I'd like you to start by explaining to listeners, what is a third stage evidentiary hearing, and what legally was our legal burden in order to try to win?
Right. So we've often referred to the third stage hearing as sort of a mini trial, but it's sort of important to remember that it's not a trial. So it's a hearing to determine whether a new trial is warranted. So in order to get to that stage, it's meant to be more lenient than a trial standard. So in order to get relief, we had to present evidence that was new, material, non-cumulative, and so conclusive that it would probably change the result on retrial. So that's a lot of stuff, but the 2 most important ones are the newness of the evidence and the conclusiveness of the evidence. So stop me if this is too much, Andy, but in order
No.
Okay, great. So
keep going.
In order to be new, the evidence has to have been unavailable at the time of trial through the exercise of reasonable diligence. So in this case, it's a little bit confusing, or not confusing, but it's tough because, we had a lot of evidence that was available at the time of trial, public news articles, witnesses who were, in the file, so could have been presented at trial, but their relevance was totally unknown. So, the interviews with the Palmatier brothers, Chester's counsel could have had access to that at the time of trial, but it would have been totally irrelevant. So that becomes a judgment call as to whether that qualifies as new evidence. The DNA, however, was new because it was in the sole possession of the state, and they didn't give it to us. And also the DNA technology is new. So then conclusiveness, and this is where the rubber meets the road in terms of the standard, the evidence taken together, weighed against the original evidence, has to be sufficiently conclusive to probably change the results on retrial. So that's kind of like a civil standard. It's more likely than not. So if all of our new evidence taken together was stronger probative of innocence than guilt against the trial evidence, then we win, if you apply the right standard.
Yeah. So here's my question. When you say probably change the result on a retrial, so at a criminal trial, the standard is guilty beyond a reasonable doubt, right? So to change the result, that would just mean the new evidence, when looked at collectively with the trial evidence, would probably lead to an acquittal?
Yes. So, and when you put it that way, would probably lead to reasonable doubt.
Right, to lead to reasonable doubt.
Yeah.
And so I want to be clear here, because we're going to talk about this, I think, as we go forward. The standard is not proving Chester was innocent.
Right. Right. So that used to be the standard that courts applied. It's called the total vindication standard. And that was rejected. We do not use that standard anymore in the state of Illinois. It used to be you had to prove your innocence, basically. Not
right.
So.
So here, we just had to basically show that our new evidence would probably lead to reasonable doubt.
Yeah.
Reasonable doubt. Reasonable doubt. Okay. So that's the main standard. We have our evidentiary hearing. You were sitting there right next to me for 3 days. I thought 3 powerful days. And the way we started out with the forensics. We called Chris Palnick from Microtrace to talk about the evidence inspection, the photographs he took of, some of the evidence, including the hairs found on Mrs. Murphy. We called Najee Bradley from Bodie to talk about the characteristics of that hair having a root and being an anagen hair in the growing phase. We then called Keely Coleman who did the DNA testing. We called the guy from Othram who did the genetic genealogy testing. That was day 1. And then we did our live witnesses. So we went through all that. And then we submitted post-hearing briefs. And our brief, you wrote it. How long was it about?
About 40 pages, or maybe longer, actually.
And so what was the purpose of that brief? Explain what the post-hearing brief is and its purpose.
So in this case, post-hearing briefs are not required at the 3rd stage, but the judge had us do them. We thought to get his handle on the standards and then have our arguments for why we met the standard, and because there was so much evidence presented, sort of put our case together, a closing argument brief that would set out all of our arguments and give the law to the judge.
So we did that, and then we actually argued it. What was it, like a week later, we had oral arguments. And then the judge wanted time to digest it all, set it for a ruling. I think it was about a month out. And then, as some listeners may know, Chester Weger sadly was diagnosed with stage 4 lung cancer. We brought a motion to expedite the ruling so the court would bump it up because if Chester were to pass, the case would be moot, correct? So
right.
He had to be alive in order to get the court ruling. The judge bumped it up a couple weeks. I was kind of surprised he didn't bump it up quicker in light of what I informed the court. But in any event, the court bumped it up 2 weeks earlier. The ruling, I think, was June 18th. And he issued a 30-page opinion, which he read in open court, which was maybe the most painful hour and a half in my 35-plus year legal career. I don't know if I've ever sat through more agony than him slow reading that opinion. And what's interesting is the way we argued the case was it's a DNA exoneration, even though we don't have to prove innocence, but like DNA, it's that was our argument. And he waited till the very end to address that. So I kept thinking, well, maybe there's a glimmer of hope here, but he didn't. He ruled against us on that. So let's walk through what the judge got wrong, in our opinion, in his order. Let's start with what you think the first issue was in your mind.
Yeah, so I mean, I had many problems with this ruling, especially because we had in our briefs laid out the proper standard. So this is getting into like sort of legal mumbo jumbo, but
that's good. That's good. Yep.
The biggest problem is that he said right out the gate that he was not going to reweigh the evidence, that the jury had decided the case, and it was not his role to undermine the verdict of the jury, which of course cannot be the case, because then nobody would ever be able to be found actually innocent and get to a new trial if you have to credit the jury's finding, which is obviously guilt, right? So he announced essentially that he was not going to reevaluate the reliability of the confession in a confession-only case because the jury had rejected the argument at trial that the confession was false. So when you start from a basis of the confession is true, well, that's kind of the whole ball game, because then Chester did it, right?
How do you win? Yeah, how could we ever satisfy Bird if he's saying I'm not going to re-examine that?
And that's not the burden. He wrote that into his opinion without a citation, so he kind of, from whole cloth, just pulled that up. And the state hadn't even argued that.
What do you make of that? I mean, how could he? I mean, he got it. Oh my gosh! This is so painful to relive. So he argued a legal standard that was not only inapplicable, it was something the state hadn't even argued. And this is after we had set forth in our comprehensive legal brief that you drafted what the correct standard was. And you said he had no citations to his standard in his order.
Right. So he sort of framed this as more of like a legal position rather than a standard. The standard that he was using, which is one that courts sometimes say, but it's not the Supreme Court governing standard. The standard that he used was that no rational juror would find the defendant guilty based on the new evidence. So that's a heightened burden compared to probably change the results, because that means you basically have to have convinced every single rational person of innocence. So that was the standard he was using, but this judicial philosophy that he laid out about how it was not his role to reweigh the old evidence or to question the jury's verdict was sort of a gloss that he put on everything.
But that actually was his role, right? That is exactly what he should have been doing. Yes. In fact, if you remember, because when I did my PowerPoint oral argument, I spent probably the first half of the argument making the point that the trial was weak. It was so weak. And the point I was trying to make is, because a lot of the cases, and I mean, you've read them, they say, okay, here's the new evidence, and now let's compare it to the trial evidence. And what's our assessment of the trial evidence? Is it strong? Is it weak? What is it? And I was walking through all the reasons it was weak. And I'll give the listeners one example. So at the criminal trial, the state paraded out, a half dozen or more lodge employees offering dramatic testimony about scratches on Chester Weger. Oh my gosh. Scratches on his cheek, bruises on his face, scratches on his neck, on his chest. I mean, you would have thought this guy just got done with a 12-round boxing match, right? And then I brought up the fact through documents that, I don't think Chester Weger had ever seen, probably his lawyer, interviews of Chester Weger in the weeks after the murders. And one of them was by the Illinois State Police, 2-hour interview. There's nothing noted about his appearance. Nothing. And all that evidence about scratches was elicited 8 months later through leading bullying questions. There was no contemporaneous reports of Chester having those injuries. So I thought on that point, for instance, alone, that showed the weakness of the state's case. But the judge in his order actually cited, there was all this scratches evidence.
Right.
And totally ignored our point on that issue.
Right. He did the same thing with the blood found on his jacket. He said that corroborated the confession, but there was minute blood spatter on one sleeve of the jacket. And we presented David Fowler, who said that the amount of blood that was going to be on whoever did this would be drenched in blood. So the jacket, which also they didn't type it or link it to any of the victims, so it could have been from anything. But setting that aside, it was inconsistent with him having been the perpetrator. The judge, because the jury found him guilty, assumed that it was corroborative when really it was the opposite. So he did that with almost every piece of trial evidence. In the modern era, I don't see the evidence leading to a conviction ever, even just the old evidence, because we know so much more now about...
He wouldn't even get charged now
right.
With the case. I mean, if it was it's a confession-only case, and a confession that comes up post-arrest, there's no probable cause to arrest him. And I also think with David Fowler, I'm jumping ahead here a little bit. So David Fowler was an expert forensic pathologist, we hired. He was talking about how the murder weapon would have had to have been something very strong, swung with force, like a baseball bat. He said there were two types of injuries, rounded and pointed. So the bat could have caused rounded injuries. A tire iron potentially could have caused the pointed injuries, not the wooden log. And he explained how when you're swinging something with force, the force applied to the object you're striking, that same force is applied to the object. So this rickety old log would have been damaged. And the judge just completely discounted that. He acted like Fowler was only relevant to Roy Tyson's testimony.
Right. I mean, Fowler also corroborated our theory that the crime was not a robbery gone wrong. The injuries were so consistent with vengeance. All the injuries were centered around the head, which is not the way that it would normally proceed from a struggle. This was, very deliberate bludgeoning of the head and face. But that was not new evidence, right? Like the injuries were known at the time of trial. So the judge was sort of able to discount what was there. I guess it's frustrating to me. The case was so weak, basically, that it would not get a guilty verdict now. But the judge ignored that.
Right.
Because they did get a jury verdict.
I felt like if we had a feather, if the whole thing was there's a scale, and to get reasonable doubt, it's got to just lean in one side. If we put a feather on that scale, right, it would have been like, okay, now there's reasonable doubt because the case was so weak. And we're going to talk about this in a minute. Like nothing on our side got credited at all. And I go back to, maybe it's not considered new evidence, but in terms of argument, right? We're entitled to argue why the evidence was weak. And with those women having those devastating injuries, it's not consistent with Chester's bogus confession saying he accidentally killed, woman number one. So then he had to kill the other two. Okay, he had to kill the other two by fracturing their skulls,
right,
and inflicting so much damage that their faces were unrecognizable. That's not somebody who's just killing somebody because they don't want them to be a witness. There's something else going on there. And I will say what I thought was so persuasive about David Fowler was a couple things. He said, your skull is a helmet for your brain. It's so strong. It's hard to break. And he talked about Mrs. Oding having this O fracture where I think he said you see it oftentimes like in motorcycle accidents where at a high-speed motorcycle accident, somebody gets ejected from the motorcycle, their head hits, the pavement, but the force keeps going, so their body is just whacked. That's what she had. Like her skull's loose on her spine. And he just very casually and conveniently just kind of dismissed David Fowler like, oh, this isn't really relevant to Roy Tyson. It kind of contradicts Roy Tyson.
Well, and the other thing, the missing fingertip.
Oh my God.
That was known at trial. Well, that's true, but it's his role to evaluate that evidence in light of the new evidence. In light of the new evidence, that has a totally different meaning than it did in 1961. So he just completely disregarded anything that went against what the jury already found.
And let's explain that. So at the trial, the criminal trial was only a trial regarding the murder of Lillian Oding. So unfortunately, there was no evidence presented about Frances Murphy, who's the one with the missing fingertip, who's the one with the soiled clothing, who's the one with the vaginal bruising. But yet the state argued over and over and over again, like 100 times. They would talk about all three bodies, all three murders, all done at once. And there's nothing in Chester Weger's confession about a fingertip missing. And one of the things we don't have in the file, there would have been interviews of Chester Weger, right? Preliminary interviews, just talking to him, getting him to, whatever he's saying. They would have surely asked him, wouldn't they have, about a missing fingertip? There's nothing in the file about that. And I think, like you said, once we produced evidence of the Chicago Mafia's involvement, in particular, Frances Murphy's husband, Robert Murphy, potentially being the person who ordered the hit on his wife and all three women had to die. Now the missing fingertip makes sense.
Right.
Because how can it make sense otherwise? How can it possibly make sense in the Chester Weger lunch break triple murder confession?
Right. And the same thing with the injuries. They were consistent at the time and now with multiple offenders. And now we have a theory that also is consistent with multiple offenders. And the judge just said, well, Chester confessed to being the lone offender, and the jury believed that, so I do too. Just completely disregarded his role.
What I want to stress about what you said was, so when the judge set forth this kind of legal framework, he did not cite a case. Explain to listeners the concept of precedent and why you cite a case and how that works.
Yeah, so the way that we develop law in America is sort of ad hoc. You have legal standards, and they're applied on a case-by-case basis. And they can change over time based off of the highest courts in the land making a ruling that governs the lower courts. So when a district court, like in this case, is applying the law, they have to apply the law of the courts above them. And the intermediate court has to apply the law of the Supreme Court or co-intermediate courts. A district court does not make law. They have to apply the law. And so you have to cite a case and apply that law. Basically, a court can say what they want, but on appeal, they will get knocked down. So his standard would have absolutely have been found to be error.
By an appellate court.
By an appellate court.
And you clerk for an appellate court.
Yes.
You've written appellate court opinions.
Yes.
And so you can't just make up the law as a trial court.
Right.
You have to apply the law that's already been established for that legal proposition. And so for the court to cite this legal framework that was not the law, and that's why there was no case cited, because there's no appellate court case setting forth that framework.
Right.
I think that was one of the things that was, well, there were a lot, but that was particularly frustrating when he just took, and I think the way you described it to me in one of the conversations was, instead of conducting his own analysis of the trial, the criminal trial, he just rubber stamped it. Right. And I'll give you another example of showing how the trial was weak. I was looking through the testimony, and this is just in the trial record. Dr. John Maloney, who did the autopsies, was saying the women would have died. I think he said they would have, no, he said, I think it was the blood in their, like in their, was it in their lungs, would have happened within, I think it was like, I think he said like 45 minutes or an hour, of them having lunch. And then I was able to, and I'm just giving you general timeframes here, and I was able to show that they were seen checking into getting their meal tickets at 12:28 p.m. They went right to the lunchroom, and if you presume they've eaten some food by 1:15, let's say, which is 45 minutes, that blood, they're getting attacked by 2:30, and there was testimony from Emil Bohm in the kitchen, another employee, who saw Chester in the men's bathroom, I think at 2:40. So at the time this blood should be entering the women's like lungs, Chester Weger's still in the lodge. And so that's kind of an exonerating timeline showing that the trial was weak. It actually showed Chester's innocence. He didn't even address that point in the order.
Well, and I argued this in the brief, but the point of an actual innocence petition, the reason that we're allowed to bring them as a collateral attack on the conviction is because there's a grave concern with innocent people being in prison for a crime they did not commit. So the point of this whole process is to identify the cases in which somebody's probably innocent. The courts are concerned with people that are innocent being in jail. They're not concerned with itty-bitty technicalities that even though the person is probably innocent, we're going to leave them in there because they don't meet these technical standards. It's not meant to be a gating process for actually innocent people to have to jump over. You can use your common sense, and if somebody is probably innocent, they deserve a retrial because that's the harm that you're trying to prevent with this whole process. We as a society have a value against innocent people being in prison. And the way that the judge approached it was starting from the belief that you shouldn't be able to ever prove your innocence, even in an abundance of evidence. So he discounted that evidence that was in the trial record that showed innocence because it was in the trial record. But that has nothing to do with whether it shows innocence. So He didn't see the forest through the trees because he didn't want to.
Yeah. And he said something like, oh, he confessed. He confessed. Like, I mean, yeah, we know he confessed. The point is, how strong or weak is the confession? And we walked through, you and I, all the ways the confession was not corroborated, right? Log wasn't the murder weapon. The timing, the story made no sense. The blood on the jacket, the twine wasn't linked to the lodge. All these things. That just completely fell on deaf ears. So that was pretty. What I just don't have an explanation for is how he could be so off base and got it so wrong. And I'll leave that to people to speculate, and people have their own opinions. All I can say is the legal standard, in our opinion, was wrong. Right.
Right.
So that was the first big one, and that's a huge one. Just taking the trial evidence as gospel. Our new evidence can never overcome that because he's taking it as absolutely true. He's not assessing today the strength or weakness of it with a judge's common sense and review. And
I think our listeners know that based on the trial evidence alone, it was impossible for Chester to have done this. And if you take that impossibility off the table and say that it's impossible that he didn't do it, of course, there's no path to victory.
There's no path to victory, right? What was another one of the big legal errors you thought the judge made?
So the next big legal error was the DNA evidence. He totally discounted our DNA evidence, starting from what we talked about earlier, this total vindication standard. So even though the DNA evidence led to a different person who was a local brother, the DNA evidence was 4+ follicular material and an antigen hair. So that means that the hair was plucked or removed from the head of the person by force, which is, again, consistent with a struggle, and not with contamination. Also, there was more than one hair. So, again,
it is found on Francis Murphy's fingertip, right, where you'd expect it to find it if there's being pulled out.
Right. So his conclusion with the DNA evidence, he said. So his conclusion on this is about the legal standard that he was using. He found he could not conclude that the hair on Mrs. Murphy's glove must have come from the killer, or that the hair is conclusive proof of defendant's actual innocence. So, of course, we did not have to prove that was the killer. We did not need to prove an alternate offender, and we did not need to prove that hair alone was conclusive of his actual innocence, although I believe that it is, including in terms of the right standard for conclusiveness, which would probably change the result. A jury that heard that there was the only forensic evidence at the crime scene is not Chester would probably acquit Chester. That would probably be reasonable doubt, right?
Yeah, reasonable doubt. I'm looking at page 30 of his opinion. Or that the hair is conclusive proof of defendant's actual innocence. That's not the standard.
Right.
And what's so frustrating is we filed a very comprehensive legal brief, did we not, explaining this?
Yes. So he also did ridiculous leaps of logic and speculation on why he got to that conclusion. So also reading from the page 30, he's found that the DNA was not sufficiently relevant or reliable because Edward Bray, the person who through genetic genealogy was the contributor to the hair, died on the morning of the same day Miss Murphy's body was discovered, and the deputy coroner handled both bodies. So there, he's assuming or trying to prove up a contamination argument, but there's no evidence that the same deputy coroner handled both bodies. There was no evidence that the deputy coroner handled Ms. Murphy's body, and no evidence that he handled Edward Bray's body. There was evidence that he signed the death certificate for Edward Bray, but signing a death certificate does not mean you handled the body.
People listen to this. If you're watching on YouTube, you can see this whole time I'm shaking my head. This makes me want to scream. So I've got the death certificate here, and I'm going to post these documents again. I think I already have, but I'll post them on the Andy Hill podcast website. So let's pause there. So I want to read, that's such a good point, Sally. He says, the hair's relevance as evidence from the murder is diminished by the fact that a person who matched the hair died in the morning the same day Miss Murphy's body was discovered, and the same deputy coroner handled both bodies. How can he say the same deputy coroner handled both bodies when all we had in the record was that the deputy coroner signed Edward Bray's death certificate the day after the women's bodies were found on March 17th. That's the date he signed it. That's all we know. We don't know whether that deputy coroner did anything else. And that deputy coroner testified at the trial, criminal trial, to going down to the cave. It was all roped off. He supplied some cots used to take the women out of the canyon. They were brought back to his funeral home, and the bodies were then put in his funeral home where a Dr. Maloney did the autopsy, not the deputy coroner. And this is something I want to read out of Will County. So Will County, just for listeners to explain this, the Will County State's Attorney's Office was appointed to be the special prosecutor to represent the state of Illinois. So the Will County State's Attorney's Office was who we were litigating against, and they were representing the state of Illinois. So I'm looking for this I'm looking at their brief that they filed. And so really, I think I kind of argued this a little differently at the oral argument. Really, their argument was this zipper contamination, which is even more ludicrous. So let me read this part to you from page 42. This is the words they use. The most likely inference of all. All right? What I'm about to read to you, they're going to say is the most likely inference of all is a simple case of a transfer of a single hair. Deputy Coroner Hulse testified that part of his equipment was a morgue cot with an attached, fastened, and I love this part, and very likely reused zipper bag. One of the victims was placed in this bag. Of course, hair can get pulled by a zipper. Are you kidding me?
Right.
So let's pause. What they're saying, and again, I think I'm going to have a day a year. I'm going to maybe it'll be like, the day we're recording this, or the day this airs. Every day I'm going to go outside my backyard and scream at the top of my lungs in honor of this point until I die. The most likely inference of all is that, let's play this out, even though there's no evidence of this. Edward Bray gets put in a zipper bag, okay? A hair gets yanked out of his head that's got a root. It's an anagen hair. It's growing more than one hair. Gets lodged in the zipper somehow. Okay, again, there's no evidence of any of this. That zipper bag, and that's at a funeral home in Utica, okay, in Utica, Illinois. That zipper bag is then reused for the women. It's brought down to St. Louis Canyon, and Frances Murphy is somehow placed in that same zipper bag, and then the Edward Bray hairs that get lodged in that zipper at some point get unlodged from the zipper and miraculously land on Frances Murphy's left index finger, which is, by the way, the finger that had the fingertip cut off. That is what the Will County State's Attorney's Office is arguing. In a state's attorney's office whose job is to seek justice, not merely to convict, is saying is the most likely inference of all. I want to just, my head is going to explode again.
Yeah, I mean, so the Will County State's Attorney's Office argued ridiculous stuff, and then the judge just picked it right up and made additional ridiculous inferences from nothing. So I want to quote him here. The defendant's assertion that the hair must have come from the killer are compromised by the recognition that, to be true, it means a 60-plus-year-old man was sent to Starved Rock to assist in the killing 3 women at the end of a long canyon. And he just sort of like leaves that there as if that's impossible, or as if because you're 60 years old, you can't kill somebody. I think that he should probably look at the IDOC records for how many people.
I'm 63 years old. I just turned 63, and I feel pretty good about my physical capabilities. I can walk, I can run, I could drag a body into a cave, I could swing a baseball bat, I could do all those things. And I think there's a lot of 60-year-old people, and I think the way you explained it to me before, and I love the way you said this, was and this is what Edward Bray was, a 60-year-old security guard at the Seneca shipyard is no less capable of murder than a 21-year-old dishwasher on his lunch break.
Right.
I mean, and the state didn't even argue this, really. They weren't even arguing like he was too old to be down there. We've always said it was a crime with, multiple offenders, multiple attackers. So, I mean, are you kidding me for him to say 60 years old? He's throwing this in there?
And he just leaves it there as like, you have to draw the inference from what he's saying, which is that he's too old to have been involved in the murder. But yeah, putting side by side the state's theory against this, it's way more likely that a 6-year-old was one of 5 to 6 people that were sent there by the mafia than one 21-year-old. When you look at the totality of the evidence, it's just crazy. It's just crazy.
I want to go back to this. So what is it about? I just I can't let this go. And I'm never going to let this go. I will not let this go. I had a whole slide. I remember, this was in my rebuttal oral argument, because I actually addressed this in my opening argument because I knew Will County was going to bring up this bogus contamination issue. It's like, okay, where is the hair found? It's found on her finger, which is exactly where you'd expect it to be found if she pulled it out of somebody's head. It's not found on her shoe. It's not found 10 feet from her body. It's found on her left index finger. Okay. How many were there? There was more than one. Okay. Which defeats, I think that sheds light in this, this contamination theory. As Najee Bradley from Bodie testified, it was an anagen hair, meaning in the growing phase. It had a root. On a scale of 1 to 4 for follicular material, she gave it a 4+. And she said in her testimony, it's like when you pluck an eyebrow out, right? Like you got a little kind of like bulb at the end of like your eyebrow, like it's plucked out by force. That hair is found in her finger. It comes back to one of the Bray brothers, Edward Bray, who's the youngest brother, who's 60 and works. He's single, and he's a security guard at Seneca shipyard. Why? And I'll use the Will County's words, the most likely inference. Why isn't the most likely inference of all that he was down in that canyon struggling with Mrs. Murphy, and that's why that hair is on her finger? Why isn't that the most likely inference?
Well, right. And we don't have to prove that is what happened. So the court and the state said, we were trying to prove that he was the killer. But no, we were trying to prove that his hair being there provides reasonable doubt that Chester is the killer, right? So that's one thing. The other thing is, at oral argument, the state kept making a big deal about how, isn't it convenient, like, that he died the next day? Like, you think that he was committing this murder on the day that he died? Sort of trying to make the argument that, yes, he was too old, like he was frail and he died, he was in poor health. And then also adding to their contamination argument, of course, because he was in the funeral home at the same time. It actually supports our theory. It's a little, yes, convenient, but if he was involved with the mafia and maybe a little bit older, him having committed a murder would either cause a health issue, heart attack.
Yeah.
Or he was whacked. I mean,
right. I mean, when I first heard he died, all right, so the murders happen on a Monday. The bodies are found on a Wednesday. He dies on a Wednesday. When I hear he died 2 days later, I'm like, well, that's pretty weird. He dies of a heart attack 2 days later. This had to have been, can you imagine how the stress level, being down in that canyon and being involved in brutally killing these 3 women? There's obviously a struggle with these 3 women. So I go back to, how can Will County argue the most likely inference of all? That's a direct quote on page 42 of their brief, is this zipper thing. Again, when there is no evidence at all, that Edward Bray was put in a zipper bag We know from his death certificate he's at a funeral home in Utica. The women are brought to a funeral home in Ottawa. And to argue this whole Zippergate issue is absolutely ludicrous. And like you said, to think that the judge bought it, and then when the judge says handled both bodies, that is just
right.
I don't think sloppy is the right word. I think it's just it's more than that. I mean, you know, it's not like sloppy. It's no, you're saying something that's wrong.
Yes, and I'm looking for in the opinion, he said some other stuff that, yeah, he was just sort of leaving out there without saying why he was saying it, but something about how, let me find it, that juries don't expect DNA.
Yeah, no, this is what he said. It's I have this highlighted too. This is what he says, and you can explain to me what you think this means. On page 30 in that same paragraph, his first line is, leaving a strand of hair at a murder scene is not so common that jurors expect to see it in most cases. I have read that so many times. I still don't quite understand the point he's trying to make.
Yeah, I mean, I'm baffled. I do not understand. I really don't get it.
I think maybe what he's trying to say is jurors seeing that hair, they wouldn't necessarily think like, oh, it's got to be from the crime scene. It's got to be from one of the killers, because that's what happens all the time. People leave hairs and, you know, that's what it's got to be. He's trying to, I think, make the argument that this is so unusual that a jury maybe would not have given it the weight, perhaps, that you and I think they would have given it, which is nonsense.
In reality, it's the opposite. Jurors trust DNA almost too much. DNA evidence wins the day all the time in cases where there's evidence that goes against the DNA result. Because of they call it the CSI effect, you know, where jurors love forensic evidence and they give it a lot of weight. So he, again, without citation, is just, and he doesn't explain it at all.
No. You know, I think the judge had to really do some legal and factual gymnastics to try to dismiss the DNA. And I think what's interesting is, and Will County did this too, our evidence presentation, both at the evidentiary hearing, you know, day one was all DNA, all forensics. Day one was all our forensic people. It was a DNA result. And I argued this is a DNA exoneration, even though exoneration is not our standard. Reasonable doubt's our standard. What Will County did in their post-hearing brief was they argued about everything else, and then at the very end, they're like, "Oh yeah, and the DNA, that's the zipper." And the judge did the same thing. He packed it into the very end of his opinion. You know, he's talking about this on page 30 of a 32-page opinion. You know, like he doesn't lead with this and explain this robustly and fully and thoroughly. Well, that's where we put all our time and effort in.
Right. Well, and that when he was reading it from the bench, I was maintaining hope the entire time. I thought he put it at the end because he was going to fine for us on it.
Yeah.
That was so disappointing.
I just still cannot believe that. And I remember I argued something like this. I said, you know, at a retrial, Will County would be free to make this ridiculous contamination zipper argument. They're free to make it, but it is such a weak, ridiculous, unsupported, no foundation argument. And I remember at the time I argued this, I looked over to their table and I said, shame on the state. Shame on the state, because I felt like there was no foundational basis, you know, in terms of evidence or facts to make that argument. And here, the thing with Edward Bray is, it'd be different if there was evidence elicited that Edward Bray was a pastor at the local church. Everybody knew him. He was the greatest guy in the world. The time the murders happened, he was giving a sermon and he couldn't have been down in the canyon. It makes no sense. There's got to be some reason, you know, he died 2 days later, so it must have been some contamination issue. There was nothing presented about Edward Bray other than that article that, let me find it, that Will County introduced into evidence that I think it said, you know, he was this night guard security guard at the Seneca shipyard. That's it. So there's nothing about the Edward Gray profile at all that makes you think, oh, this guy couldn't have been down there in the canyon. Why not? Why couldn't this security guard at the Seneca shipyard been down there? It actually sounds to me like kind of a rough and tumble guy who's a security guard at the shipyard. That actually sounds like.
But he's 60 years old, so.
Yeah, he's 60 years old. You know, I mean, I don't know. Do the loyalty, trust? You know, I mean, so I mean, the whole notion that there's no reason to discount the most obvious inference of all, which is so strong, which is that it's his hair on Mrs. Murphy because he's down there, you know? And even if you want to say, I mean, what you have to say is it's reasonable doubt, right?
Right.
I mean, how is it not reasonable doubt?
Right.
It just, all those points. Is there anything else you want to say about the DNA evidence?
I mean,
oh, good Lord.
Kind of another legal argument about whether it was relevant even. The judge made this he kept asking questions about it throughout the whole case about whether evidence, because it was found on Ms. Murphy's finger, would be relevant in the prosecution of Oding's murder. And this bothered me as well. He ultimately didn't make this a big foundation of his opinion, but you could tell that he was trying to find a way to discount the DNA evidence, and that would have been one of them. But the state at the original trial presented all sorts of evidence about all three women, and clearly the state's theory of the case was that Chester killed all three women. That's his confession. Clearly they were killed at the same time. It's the same case, just three homicides, right? And the judge kept sort of maintaining that this would not be relevant at a retrial because it was not found on her. Any DNA of anyone's found in the whole canyon would be relevant to who committed these crimes, right? The standard for relevance is really low. So it's just like whether the evidence makes a fact more likely than not to be true. And if there had been hair anywhere in the canyon, that would have relevance to who committed these murders. So you could sort of tell from out the gate that he was trying to find an avenue to discount the DNA. And so when he says in the opinion that the relevance is diminished, that's what he means. He's saw it as being less relevant anyway because it wasn't on her body. But I made this argument. If that hair had come back to Chester,
yeah,
I'm pretty sure the state would have been presenting it.
Well, that's another thing that gets overlooked. That hair, and I think it's literally the same hair. So that hair, just for people, the other powerful thing about it was the hair. So we're kind of discounting the way it's inventory, right? You know, it's in the glass slide. It's etched with a diamond stylus where it came from, you know, Francis Murphy. And the point I want to make is there was no reason that the state suspected there was any contamination back in the day. You know, there was no reason. The state sent that hair to wash you, to wash you med school, your alma mater, for analysis. And it came back. It came back less than a week after Chester's air quotes confession that the hair is dissimilar. They sent it there because they thought, A, it's relevant to the crime for sure. And they wanted to see whose it was, if it could match it to Chester. And they would have, yeah, hell yes, they would have used it against him. You know, the point I want to make, I think we just flooded him with so many facts he couldn't use the argument that that hair had no relevance because it was on Francis Murphy, because we noted in the trial record, the state at Chester's criminal trial kept referring to all three victims, kept showing photographs of all three victims. They actually called as witnesses, if you remember, Robert Murphy, the husband of Francis Murphy, Mildred Lindquist's husband. All the husbands testified. And several times, Chester's lawyer, John McNamara, moved for a mistrial because the state kept bringing up all three murders. And the state itself, back in the day, argued res geste. Did I say that right? Mm-hmm. Like they're saying it's all part of the crime, right? All three women, they're all killed at the same time by the same person. And so,
which leads me to another thought that the court discounted an argument that we sort of made, which is that they charged him with only that murder because they knew their case was so weak that they might not convict. And they didn't want to have double jeopardy prevent them from retrying him. They're going to do it serially so they can get a conviction eventually. And we have other evidence that the state knew its case was weak. They thought it was a ridiculous confession, etc.
Yeah.
And also another point that the judge didn't credit at all is the fact that they did not give him the death penalty, even though they were seeking it.
Yeah.
And juries at the time, especially in a case like that, absolutely would have given the death penalty unless residual doubt kept them from doing so.
For sure. This is a death penalty case.
Mm-hmm.
These three women get bludgeoned to death in that cave.
Right.
And Tony Raculia. So we brought a motion shortly before the evidentiary hearing. We had those DVDs of an Illinois continuing legal education seminar on the Starved Rock murders. So it's something that lawyers go to. They can get continuing legal education credits. Tony Raculia was there arguing on behalf of Chester Weger's guilty. Donna Kelly, Chester's public defender at the time, appellate defender, was arguing the case of innocence. And Tony Raculia, who, this is, I think, 2010, so he'd have been, I think he was in his 70s at the time, was saying that the confession was absolutely ridiculous. And he went to his boss, Bill Richardson, and he said, this is absolutely ridiculous. It couldn't have happened this way. And Bill says to him, what are you going to do about it? He goes, well, I'm just going to tell the jury that's how it happened. So my point is, we tried to get that admitted into our evidentiary hearing. The court denied that. The state back in the day knew the confession was absolutely ridiculous. And what Tony Raculia also said was, the reason they, just like you said, the reason they only tried Chester for one murder was because they were worried the confession would be found to be involuntary because of the coercion of Dummett and Hess. And if it was found to be involuntary and was barred, they had no evidence. Chester would get acquitted. They wanted to be able to somehow retry him again, somehow, So then, of course, in our case, Will County gets up there and is like, oh, the confession's gospel. Oh, hell yeah, he's guilty. The confession's absolutely true. And I think that's also, I don't see how the state could argue the confession, which was so ridiculous on its face, was true in light of all the other evidence we presented. Anything else on the DNA before we move on?
I don't know.
Other than a big sigh and a big
sigh.
Tell me another one of the legal errors you thought the court made in this order.
So another one, and the state argued this at length, was that all of our evidence essentially should be given zero weight, should be completely ignored because it was hearsay. So hearsay is out of court statements that are presented for the truth of the matter asserted. So basically it's any testimonial or written evidence that is being presented because it says what it says. So yesterday it rained. There you go. That's to prove that yesterday it rained. Hearsay is typically inadmissible, but there's a million exceptions. But it's inadmissible because it's deemed unreliable, because it's not an in-court statement. There's no witness that you can cross-examine about the veracity of the statement. But like I said, there's a million exceptions. So this stuff is typically litigated pre-trial. If you've got a diary entry from somebody and that person's not there to testify, either the judge will not admit it or they will admit it. But this stuff happens before trial and it's extensively litigated. There are long briefs, motions about hearsay evidence. Here, the state was arguing basically that all of our evidence was hearsay, including our witnesses that overheard things, that were told things by Smokey Rona or by Wayne Hess, that because Smokey Rona was not there to testify and Wayne Hess was not there to testify, we should be totally ignore what our witnesses said. That is not a standard at all on post-conviction. The rules of evidence do not apply on post-conviction at all.
Say that again. The rules of
evidence do not apply on post-conviction.
Thank you.
The court admitted that. The court says it is undisputed that the Illinois rules of evidence do not apply to post-conviction hearings. That means hearsay evidence is not per se inadmissible because it fails to meet the reliability criteria. So the rule says hearsay evidence can be presented and considered at a third stage evidentiary hearing. The state argued, based off of an unpublished, so not persuasive, well, not governing law, that hearsay evidence can be presented, but then the judge can choose to ignore it, which again is circular. If the judge was permitted to ignore completely evidence just based only on it being hearsay, then why would hearsay be allowed to be presented?
Right.
Right? So it's true, a lot of our evidence was hearsay. However, if we'd actually been doing a trial, we could have probably gotten a lot of it in through various exceptions, right? But the judge then used the fact that it was hearsay to say that because it's hearsay, it's unreliable, which is not true for anything. For instance, the Zelensky memo, which I'm sure we'll get to, it is hearsay, but there's exceptions. You know, it's a police record. Anyway, we won't get into the exceptions, but Zelensky is not here to testify, right? But that is an extremely reliable account of what she said, and it's a government document, right? There's no reason to doubt its veracity. There's no reason to doubt that she said what she said, or to doubt that they recorded it accurately. It's reliable for this purpose, for the purpose of a post-conviction proceeding, right?
So the judge wanted, the judge was basically improperly disregarding our evidence because it was hearsay when post-conviction cases are specifically allowed, you're allowed to present hearsay.
Right. And there is a little bit of a dispute as to whether he could do that at all, whether he could consider the hearsay quality of it. Even if he could, he gave it way too much weight, the fact that our evidence was hearsay. He basically, as the state did, relied on that to discount very credible, reliable pieces of new evidence.
Yeah, let's talk about, since we brought up the Lois Zelensky memo, because I think this goes hand in hand with that. So just as a quick recap, Lois Zelensky was the telephone operator who a week after the murders, hears two men talking on the phone. One says, boy, they sure had a big write-up on the murders in tonight's paper. You know, the guy still has the bloody overalls in the trunk of a car. He doesn't know what to do with them. The other guy says, well, tell him to get rid of them, burn them. She hears that, and she tells her neighbor, best friend, that neighbor's best friend, Gladys Brummel. We presented her written transcript of her interview. Her husband's a Aurora police officer. So Lois Zelensky tells Jim Brummel, the Aurora police officer, what she heard. He says, you got to report this. She winds up getting an interview by the Illinois State Police, who are investigating the Starved Rock murders. And it's a very detailed 2-page interview. I've talked about it in so many podcast episodes. I posted it online. I'll post it again. She's got so many indications of reliability. She's got, I mean, she has more of the conversation she overheard other than what I just recited. They were talking about cars and a car transaction. Turns out, when the call is traced to the Palmatier brothers, Bill Palmatier owns a car dealership in Peru, Illinois. The call originates from a bar in Aurora owned by Glenn Palmatier. She's troubled. It's clearly relating to the murders. That was such powerful evidence. And again, the standard is basically reasonable doubt, not proving innocence. And what happened down the road, and then we'll talk about it, they gave polygraphs. Harlan Warren, the state's attorney, when he was doing his rogue investigation, uses his own hand-picked polygraph people to give polygraph exams to the brothers and Lois Zelensky. And then, guess who failed? Lois Zelensky. And it wasn't even failed. The judge barred our polygraph expert, who basically said the way that Lois Zelensky's polygraph report was written made no sense, because it was worded in a way that, if anything, I think he said, at best it was inconclusive, not being untruthful. The judge barred that as new evidence. But then the judge used those polygraph results as like gospel. Well, I guess she was lying and the brothers are telling the truth, so end of story.
Right. I mean, those were our exhibits, and we presented them with the context of a cover-up, how they just deep sixed the Zalunzik memo and didn't go far with the Palmatier brothers intentionally. Our theory of the case is that the state was dead set on Chester and was intentionally not pursuing other avenues. That's why we presented these polygraph results, to show how fishy it is, right?
Right.
And he took our own evidence and presented it as gospel without even addressing why we admitted these exhibits.
Right. And he says something in here. This is page 20. Let's see. It looks like it's page 24. He says, there was nothing to contradict the Palmatier brothers' claims that they were not part of the conversation. This made me, again, scream. Yeah. They traced the call to Bill Palmatier's house in Peru. Of course he's going to deny it. What's he going to say? Oh, yeah, that was me? Of course he's going to deny it. And the fact that a polygraph is meaningless, it's not even admissible. So if you're a detective investigating the case, whether he passed or failed a polygraph, who cares? You're going to keep investigating. You're going to dig and dig and dig. And Lois Zalunzik, there were two heroes to the case. Frances Murphy, for struggling with her attacker and getting that hair on her finger, and Lois Zalunzik, she cracked the case. And for the judge to basically throw all that out the window based on the polygraph results, which he cites at page 24, I mean, without talking about the context, and he even made a jab in there about how she got the phone number wrong.
Right.
I mean, that was totally an unfair comment. The call got traced.
Right.
The call got traced.
And there is nothing to disprove that they made the call. Yeah, the tracing of the call disproves it, right?
Yeah. So, I think at the time she thought it was a LaSalle party. Okay, the guy, he lived in Peru. It's LaSalle, Peru. I mean, they wound up tracing the call. So it's a meaningless thing he's bringing up, acting like she had a whole different phone number wrong, and this is all off base. Glenn Palmatier in his interview admitted, yeah, I think I talked to my brother that day, and I think I talked to him a bunch of times. He maybe even talked about the murders with him, And when we tied that up with the Glenn Palmatier interview, which, by the way, we only got our paws on it because Steve Stout, that local author, donated documents anonymously to that Utica museum, and we got a tip that the documents were there. We had never seen that Glenn Palmatier interview, where after he denies being the one making the call, the Illinois State Police on their own say, yeah, but what about this Lupe Cardenas guy that we see you talking to every day here in the bar? Did you know he's got a known criminal background? He's a hoodlum, blah, blah, blah. And he's like, oh, I don't know anything about that. Well, guess what? Our research showed Lupe Cardenas is tied to where? Chicago Mafia. Now we're connecting all the dots, and the judge didn't even address that, just dismissed it.
Right. I mean, another, again, ridiculous, speculative thing that he says is there's nothing to say that the murders referenced by the two people talking on the phone was the Starved Rock murders. Well, which other murders might they have been?
Yeah. And here's the thing. In that memo, so when the judge is putting all that weight on the polygraph exams, which is just, that was such a unpersuasive argument by the court. In the actual 2-page interview, it notes that the Aurora police that interviewed Lois Zalunzik found her to be most sincere. And then the Illinois State Police as well said, yeah, we find her to be most sincere. So in the memo itself, the people that met her are vouching for her sincerity and her credibility. So the way this got dismissed, and I remember at one point I said something to the court that I actually think the person making the phone call was Lupe Cardenas, because the way Lois Zalunzik reported it was a guy with very limited vocabulary, sounded like he was reporting to the boss. We know from the Illinois State Police that Lupe's in the bar every day, hanging out with Glenn. I said, it sounds like Lupe made the call. Remember, the judge looked at me like, well, that's kind of a stretch, right? No, it's not a stretch, Right. What's a stretch, and it's beyond a stretch, is that the hairs got caught in a zipper from this whole cockamamie story that Will County came up with.
Right.
So the Lois Zelensek part was such powerful evidence. And again, you don't think if we presented that at a retrial, people would have been like, what? Reasonable doubt?
Right.
Yeah, what other murder are they talking about? There was a big write-up on the murders in tonight's paper. And she even says in there, I could tell they were talking about the murders. And there's nothing from the police,
right.
Aurora or Illinois State Police, like, well, what murders are you talking about? Or this is in the paper every day. Right. This is within a week of the murders. I mean, it was a huge, huge story. So there's another legal error I want to talk about. This explain the issue of assessing the evidence collectively. Right. Explain the standard and explain what the court did.
In order to get relief, in order to get to a new trial, the new evidence taken together must be sufficiently conclusive to change the results on retrial. So you have to look at all of our evidence as a whole and determine whether, if all of that evidence was presented at a retrial that also presented the old evidence, whether the result would be different. What you don't do is go piece of evidence by piece of evidence to see, okay, would this witness who says that Lois Zelensek was a credible witness, would that change the results on its own, right? No, you have to take it all together and assess it in the aggregate. So even though in our case, the DNA standing alone would probably be enough, you didn't need to look at it alone. You had to look at it with everything else combined. So the judge here took it piece by piece by piece. And the only time that he ever used the evidence in conjunction with itself was to say that our evidence was inconsistent. So then to dismiss it out of hand. But that's not what you're supposed to do either. It's taken together. Would it change the results? So little inconsistencies are outweighed by the overarching huge amount of consistency across our evidence.
Yeah, and so for the court, for each piece of evidence, say, well, they presented item A. That's not enough to change the result. Right. They presented item B. That's not enough. Collectively is how the court should have considered it. And isn't that just black letter law? Is there any dispute about that being the proper legal standard?
No dispute. I think that it gets a little bit hairy when you add the new part. So a lot of our evidence that we presented was maybe technically not new. There was a bunch of evidence that was sort of in the file, but would have no relevance to anybody until you start putting the pieces together. And so the judge ultimately admitted a lot of that stuff as corroboration for the ultimate new fact we were trying to prove, but then only went that far. So for instance, with Dr. Fowler, he said or maintained that we had presented that to corroborate Roy Tyson's testimony. But that was not the only reason we presented it. We presented it of new evidence of innocence. And so he discounted the whole Fowler report just by saying that it didn't corroborate Tyson's testimony because it didn't exactly match up with the story that Roy was told by Smokey Rona. That's not the standard. He did not assess the new evidence in its totality.
That was really shocking to me that there was not this. That seemed like the clear black law letter standard that you've got to look at the new evidence collectively, right, and whether that's enough, and the court not doing that. And so with the DNA evidence, we talked about that. And then with our live witnesses, for each, basically the judge just found reasons to say the person was not credible. We called Roy Tyson, who told the story, he was friends with Smokey Rona. Smokey Rona told him this story about how the Chicago Mafia reached out to him to plan the murders. His story is admittedly, got some weird components to it, but he tells it, I think he tells it, the long story, and he tells it authentically. He doesn't come across to me like he's making things up. And I thought for all the witnesses, the judge would throw in these characterizations, like these credibility characterizations that I did not agree with. He would talk about their demeanor on cross, their different demeanor on cross. And I didn't find that with any of the witnesses. I didn't think anybody came across on cross differently. I thought Roy Tyson on cross was given it right back to the state and held his own. Same thing with Melissa Smith. And then, the one I think that was most upsetting was Randy Reynolds. He basically, who was at the Dummett retirement party, overheard him say, yeah, I thought Chester was innocent, but I got the son of a bitch to confess. Said that wasn't believable, that he had such a detailed account, but yet, didn't do anything about it and, blah, blah, blah. I was like, so that Randy Reynolds should have been, take our DNA. Okay, they want to argue the bogus zipper, ridiculous contamination thing. Take our DNA evidence, take Randy Reynolds, take Melissa Smith, take Roy Tyson, take James Woods, take Diego Fowler, collectively, take Lois Selensek, collectively is the reasonable doubt.
Well, right. And another thing that the judge did, which was improper in terms of making credibility determinations, is he said, because the state asked each of our witnesses, why are you here? Like, why did you decide to come testify today? And they all said, because I believe Chester is innocent based off of my knowledge, what I've been told or what I experienced. I believe he's innocent and that a horrible injustice has been done. And that's why I took time out of my day to come here and testify. And that's why I came forward to Andy. And the judge basically said that made them not credible. So anybody who believes Chester is innocent and who that's why they're there is to help him prove his innocence.
Yeah.
Somehow that makes them not credible.
Yeah, right. None of these people had a dog in the fight. Right. I mean, Randy Reynolds, and the fact that I found some of these people because of my efforts through a podcast, which is exactly right. The purpose of when I started the podcast was to try to find people that knew something. And lo and behold, I found a couple. I didn't find a million. I found like 3, right? I found Roy Tyson, Melissa Smith, and James Woods, and Randy Reynolds. I found 4. And so, when he says with Randy Reynolds, I'm looking at page 17, the court accepts that Reynolds attended the party, but the court finds that the surprisingly detailed comment about what Demet said, namely that Chester Weger was innocent and I got him to admit it, is not believable.
Right.
What? So Randy Reynolds is making it up? Right. He's making it up. Did you? Right. This guy was so authentic. And oh my gosh. So for the court just to kind of backhand all our live witnesses and be like, well, I don't believe any of them. They're not reliable. And I thought the state in their oral argument was throwing in a lot of sarcastic jabs about, oh, this isn't a podcast. This isn't a Facebook group. This isn't internet. Like they were mocking the way these people found out about, my efforts to prove Chester Weger's innocence. This is, like you said, the fact that they came forward because they had genuine information to share shouldn't make them not credible or reliable. And I also thought in a case where I thought we overwhelmingly met our burden of showing reasonable doubt, I think we actually showed exonerating evidence. I thought the state's whole tone, I wish there'd be an audio tape of the argument because the state, the attorney for the state, I thought, how would you describe their demeanor during the oral argument?
Unnecessarily condescending, angry, and vicious, honestly. It was so high volume and so angry. I guess that's how I would describe it. It was really passionate was what I was going to say, but it was beyond that. It was I felt like it was mocking and yelling. And I thought for a case, this, Sally, I've been doing this a long time. I graduated law school in 1987. So if we do the math, what am I on my 38th year? This is the most egregious case of injustice I've ever seen. It will be the most egregious case of an injustice I've ever seen. It is stunning what happened in this case. And the thing nobody even talks about is Chester Weger getting arrested before he confessed. So they know that they've tried to break this guy every which way, and they couldn't. So they finally play their final card is, screw it, let's just arrest him, handcuff him, serve him with the arrest warrants, and then that's what got him to break. But my point is, in a case like this, it wasn't like the state argued it like, well, we understand, Mr. Weger's points, but this is the evidence that we think supports the conviction, and we still think that, these are the reasons why it's valid. It was you would have thought we were trying to prove the innocence of John Wayne Gacy, like they're just like mocking the audacity, like,
who is Andy Hale and Sally Cohen and Celeste Stack to be arguing that this guy's innocent? Like it was so outrageous that we were arguing for innocence. I mean, that's what was so stunning to me about the way it went down. Did you? I mean,
right? And I mean, they were acting and argued this really strongly that it was outrageous and ridiculous. Oh, the mob. Oh, of course it was the mob.
Right.
You know, it's like, actually, if you look at our evidence, the mob exists and the mob was very active. And yes, it was the mob. And they were acting as though we had said aliens did it or something, right? Like, as if it was that crazy. But that's another point to the judge taking it piece by piece instead of looking at it in the whole.
Go ahead.
Well,
go ahead.
just, you know, multiple people that testified for us corroborated the Zelensky memo's inference, which is that it was multiple offenders, that it was a mafia involved hit, somebody sent people down there to do it, right? And if you take it piece by piece, maybe, Roy Tyson's story seems kind of crazy. But when you add it together with Melissa Smith and with Alice Boehm, who was actually a state witness who agreed that Smokey Rona was involved, all these people together, when you testify at a retrial, that has a huge effect on the outcome. One of them maybe would be a little too, it sounds outlandish, maybe. But when you get it all together with the actual physical evidence and the finger, all of it leads to one conclusion, and it's not ridiculous. They were acting like our theory is crazy. A crazy theory is one person, 120-pound Chester Weger, doing it on his lunch break with the binoculars, you know? It's like the game of, what was the game? Clue? It was like Colonel Mustard in the library with a candlestick. It's like, it was Chester Weger in the canyon with a log, which there's so many points, Sally, that, I mean, I'm still struggling with why this was such a fight when there were so many clues. Like those first crime lab notes, I got them right here in front of me. Let me just pull them over where, you know, the crime lab notes, where they talk about the blood on the club did not result from hitting. I mean, that's huge. That's huge. And David Fowler, talking about the club was soft, spongy, high moisture content. They tried to argue that the log would have been frozen. We brought in that newspaper article that it was 38 degrees in Ottawa that day. And remember, the court's like, well, what was the temperature down in the canyon? I mean, it wasn't freezing. It was 38 degrees. And the log wasn't damaged. All of the things we brought up. And then how about the fact that after Chester confesses and they're doing the reenactment the next morning, just hours after his confession, he probably hasn't even slept. And that's when they finally ask him, hey, basically, did you defecate on any of the women? Did you urinate on any of the women? Did you kick any of them in the crotch? They asked him that, okay? All right? You know that they've asked him that before because Mrs. Murphy's got soiled clothing. She's got vaginal bruising. She's missing a fingertip. And oh, by the way, her husband, 2 years later, remarries a woman who gave birth to a baby boy 2 months before the murders took place. And that baby boy is now an adult. And when Will County went to ask that adult if he would do a DNA test to find out who his biological father is, he said no. There's reasonable doubt. I mean, we could just have the trial again and he'd get acquitted 99 times out of 100. You know, when I tell this story to friends, what I always get is, oh, well, it sounds like it was one of the husbands. That's what I always get right out of the box with people knowing nothing, you know? So, well, I think a modern jury, again, sort of the CSI effect, you know, it's always the husband. I think that a modern jury would question why they never.
Yeah. And here's the thing. And you talked about how, I want to kind of talk about the chronology a little more. Chester Weger, you know, the murders happened March 14th. Unsolved in March, April, May, June, July, August. Now we're getting into late September. There's mounting pressure. Now in late September, Harlan Warren, the state's attorney, kind of goes rogue. And the Illinois State Police have been running the show. He decides to do his own investigation, brings in his own polygraph examiner, John Reed from Chicago, who's highly controversial. And they bring Chester, they give him a polygraph at the lodge. He's passed the first 6. He fails. And then they take him to Chicago, interrogate him all day. Dummett threatens him on the ride home. So they're trying to break him at the end of September. This is after, by the way, the Palmatier brothers evaporate. The Palmatier brothers evaporate. Somehow the powers that be, and I think it's the Chicago Mafia, had such power then, they could make the Palmatier brothers evaporate. Okay? And so once the Palmatier brothers evaporate, now we got to have somebody else. Because the real guys are getting protected. So now the 21-year-old dishwasher who's naively cooperating every time they ask him for an interview or to go anywhere or to look at his clothes or do anything, go to Chicago for the whole day. He's doing all that. And then they finally surveil him all of October, can't break him. Finally just say, screw it, let's just arrest him. And they break him. Mm-hmm. And that's how it all goes down. I want to say one other thing. I think another egregious legal error the court made was denying our new evidence, and I've got this right here, an expert report from Dr. Brian Cutler. I'm going to post this on the Andy Hale podcast website. I want everybody to look at this. It's a report talking about the science and the study of false confession, what the factors are, what the studies show, what the research shows, why it happens, and the factors that lead to it. And what Dr. Cutler says in here is all these factors that typically lead to false confessions were present here and created a grave risk of a false confession. This is based on so much science and new studies and new evidence. The court said this was not new evidence. That, in my opinion, was completely wrong. And this would have been a game changer if we got to present it. What are your thoughts on Brian Cutler?
I totally agree. The court said that it was a new opinion on old facts and that it had already been litigated at trial whether his confession was voluntary or not. But just because it was considered voluntary does not mean that you can't argue its unreliability at trial, which they did. Chester testified that his confession was false. But with an expert that explains to a jury that false confessions happen, just as witness identification has issues now that we didn't know about before. So now you're allowed to present experts to explain the factors that lead to false confessions, which are all present here. Youth, lack of education, power imbalance, deprivation of food, water, sleep.
Threats of physical harm or violence or death.
Right. And the motivation of the party who's doing the interrogation here, as we know, they decided randomly that Chester was going to be the perpetrator of this offense and went about trying to elicit stuff that would meet the crime scene. So we don't have the recorded interrogations, right? Which is, again, suspicious and fishy. If we did, we would probably have a lot more evidence of the coercion that they were using. But we do know they said, you're going to ride the Thunderbolt, which alone is a threat of violence, right?
Yeah, it's right. Threat of death.
Yes.
Yeah.
And this brings me to a point in the judge's opinion. He discounted Randy Reynolds' story about Dummett saying, we got him to confess. And this is what the judge says. The court found that this statement is not credible based on the prior trial record. At trial, the defendant denied that his confessions were true and testified that he was told what to say by Dummett. However, part of his confession included a statement that a red airplane was flying over the area at the time of the murders. This is something that Dummett could not know because there was no evidence of the plane at the scene. This fact could only be known by someone who was there. Any claim by defendant that Dummett told him this information would require this court to conclude that Dummett was so clever and intent on framing the defendant that he investigated and created corroboration that would not be present at the scene. Yes, it would require you to conclude that.
Yeah.
And that is what we are saying happened.
Yeah.
Because that is
exactly.
what happened.
Yeah. That couldn't have happened. Just like he acts like, it's like another 60-year-old guy can't commit the murder.
Right.
Oh, this guy would have had to go research whether there was a plane flying overhead. Yeah.
And this guy who threatened Chester with a thunderbolt and then was found to have perjured himself by denying that at trial.
Right.
So he doesn't seem like he's the most upstanding character.
Right. And I actually cited when we were submitting all this as new evidence, I cited Dr. Brian Cutler has testified in other third stage post-conviction hearings. Other courts have found him to be new evidence because of the science. Mm-hmm. Yeah. So, in 1961, they litigated whether the voluntariness of the confession, but what they didn't litigate, because they didn't know, was the body of research the last 60 years that sets forth what we've learned about false confessions and the factors. So it's new. It's a new expert opinion based on new science. We now know as a society today that false confessions exist. So in 1960, a confession was checkmate. I mean, Chester Weger had no chance, really, because I think everybody just thought, well, he confessed. They weren't aware that maybe, it could be false. So I thought the judge denying that was an egregious legal error. Two more points I want to make. I have a question about Alice Bohm. Okay, I have a question. I don't really know the answer to this. So the state called her as their only witness. And basically what she said was she had a little different story about what her brother told her about the murders. But he also told her, that, he was involved in it and Chester was innocent. Okay. Now, because the state called her, aren't they vouching for the credibility of her testimony? So if they're putting a witness on a stand who says Chester's innocent, why isn't that enough? Reasonable doubt right there.
I mean, I certainly think it is in a retrial. I also think that when the judge was determining whether she was credible or not, he sort of tried to have it both ways.
Well, let me put it this way. He was saying that she was telling a different story. Like her story was not consistent with Roy Tyson. Like it was like she impeached Roy Tyson almost, right?
Right.
But why isn't her story then true?
Right.
Because the court has already said the Roy Tyson story to the court made no sense. Oh, why would you pick a state park to hide the bodies? It was so well known. It makes no sense. All those things, the way the state mocked it. Okay, Roy Tyson, throw him out the window. His story is a complete chaos, makes no sense. Why isn't Alice Bohm, who the state called as a witness to say her version, why isn't her version true? They called her. Aren't they vouching for the truth of her story?
Right. And I mean, I think that they are. And I think that, yes, if you assume that the state would call this person at trial, even if they aren't legally vouching for her, the jury would find that they were vouching for her. I also found the judge's attitude towards her was inappropriate or improper. He says, the court believes she was trying to answer the questions she was asked truthfully, but her responses were confusing, illogical, conclusory, and speculative. But they weren't.
No.
Just sort of insults her testimony without saying how so, but then puts in these really nitpicky reasons to discount her. So she said the year 1998 and then quickly corrected herself to 1958. And he put that in there that she misspoke. And
then corrected herself.
Right. And for the listeners, Alice Bohm is, 94 years old, or, she's an elderly woman. And so I thought that was just unkind.
And what he says here is when the court evaluates her testimony with the trial testimony, the court concludes that it does not support a freestanding claim of actual innocence. It's not sufficient to lose confidence in the verdict. Again, in isolation. Why not collectively? Why not okay, we got the DNA. And even if you want to argue the ridiculous notion that the zipper ridiculous story is perhaps more likely than ours, we still have the Edward Bray's down in the canyon version, and then combine it with Alice Bohm, combine it with these things, all our other evidence, Lois Zelensek, and we got to create reasonable doubt. The judge, again, was just saying, oh, well, Alice's story is not enough to prove innocence, so it's not enough, But my point is, all right, fine. You want to throw Roy Tyson's story out the window? You think he made it up? You think it's bogus? The state called Alice Bohm. They can't argue her story's not credible. What if we did a retrial where we didn't call any of our live witnesses other than Alice Bohm? Right. We called DNA, the Lois Zelensek memo, and Alice Bohm.
Well, right. And the one thing, because they put her on the stand, what they definitely can't argue is that it's hearsay. And so the judge, if you read the opinion, dismissed almost every other witness as hearsay. Here, because the state put her on, they're conceding that it's not hearsay. So at the very least, this one would be presented at trial. He couldn't say, oh, it wouldn't reach the trial. So yeah, if we put those three things on.
And in a case that's so weak and flimsy, why wouldn't she alone be enough?
Right.
Why wouldn't she alone saying, my brother told me this is how it went down. My brother, when he was dying, told me this is how it went down. And Chester Weger's innocent. All that jury's waiting to hear is a reason.
Right.
Give me a reason that Chester Weger's innocent, because the story makes no sense. You're already like, there's no way. It didn't happen this way. So I thought the Alice Bohm was a big one too. And before we wrap this up, I mean, I could go on and on and on. Have we covered all the main legal errors the court made?
I think that we have. There's so many, including that he didn't even address each exhibit. So the exhibit 12, which was the forensic notes from that meeting, that was a really important piece, and he didn't address it. Of course, I'm sure he would have found a way to discount it anyway, but I thought that if you're going to go piece by piece by piece, you got to do all the pieces. I think the most frustrating part, so it was obviously frustrating that the court issued this opinion that we believe was egregiously wrong, factually and legally. What I think is just compounding it and making it the worst is we can't appeal. So to explain to people why we can't appeal. So we can't appeal because your appeal in a criminal case dies with the defendant. So we can't bring an appeal on his behalf. And unfortunately, Chester passed away. You normally have 30 days to file a notice of appeal. And he died within those 30 days. So we didn't even file a notice. If we were able to, I am supremely confident that we would have prevailed because there were so many errors. And, I really wish that we had a way to appeal, because I think that the appellate court has an interest in just saying this is pure wrong, even if it's not attached to a defendant. It would be Chester's right to appeal. It's an individual right, but having an opinion out here that says this stuff that is just completely egregiously wrong, the court needs to be corrected. If this is really what he thinks the law is, it needs to be corrected. But there's not an avenue to do that.
That's what's so frustrating, because I agree with you. I think if Chester was alive and healthy, he would have been like, well, you know what? This was a horrible, horrible, improper, egregious court ruling. But we're going to appeal. Now, the part that stinks is it's going to take us, probably a couple years to to get resolution. But 2 more years, let's do it. We couldn't even appeal. And the judge knew that when he wrote his opinion. He knew that Chester Weger was dying of stage 4 lung cancer. And, we moved to expedite the ruling to bump it up 2 weeks. So obviously there's not going to be, Chester Weger is not going to live to get through a whole appellate process, obviously, So now whatever got written that was it, and there's nothing we can do about it. But I will say this for our listeners. I've said it before. Sally and I are brainstorming behind the scenes. We got some ideas we're discussing. I'm not ready to disclose what we might be up to, but we're cooking. We're brainstorming. I think we're making some progress on maybe some potential options we might have. And one thing I think we'll do, Sally, is we've talked about a lot of legal points here. I think maybe what we'll do is we'll have you put together kind of an outline of what our points would have looked like had we had the ability to appeal. Walking through what we think the legal errors and the factual errors are. And is that something you think you could put together?
Absolutely. There's a lot there.
Yeah. So we'll do that for all the listeners. And I'm going to post this when the episode drops at the andyhalepodcast.com website. That's where I'll post these documents, all the things I talked about. You can also watch the episode on YouTube, but if you want to actually read the documents I'm talking about, go to andyhalepodcast.com. I'll post them there. And you can see our legal position paper that Sally's going to create of the things we would have brought up on appeal if we had the chance to appeal, which unfortunately we don't. I just want to say this, Sally, before we wrap it up. I appreciate all the hard work you did. You're so good as a lawyer. I was so proud of you and all the hard work you did on the law, the writing and the research. This is a huge part of what we do. I couldn't have done that without you. You were so much better at that than me. And we proved our case. We proved our case. This, in my opinion, was just there was a colossal injustice in 1961. And in my opinion, there was a colossal injustice in 2025 with this court ruling. Chester Weger did not get the justice he deserved. But we're not done fighting. Stay tuned, everybody. The final chapter, as I said, hasn't been written. And Sally, you and I'm sure will be talking every day for the foreseeable future. Thanks for joining me. I love talking law with you, and I hope for the people that really wanted a deeper dive, they got that. We'll have Sally back on the podcast again when we kind of announce our next chapter. Stay tuned, everybody. Thanks.